Good morning, everyone. I'm Lynn Haltane. I'm the Executive Director of the Victoria Law Foundation, and it is my great pleasure to welcome you this morning to our Research Network event on double-edged effects. Is technology making family violence protections more accessible? And we are really delighted to have with us this morning Tanya McKenna and Dr. Kate Hammond and Dr. Hugh McDonald from the VLF, who will take us through some of the recent research and consequences, I think, of some of the technology that's been introduced around family violence intervention orders in particular. But first, I want to acknowledge that yesterday was a milestone day in our journey towards reconciliation. The First Peoples Assembly of Victoria announced that it was ready to start negotiating a treaty, which is a really important development in our journey towards true reconciliation. So we respectfully acknowledge that the Victoria Law Foundation officers stand on unceded Wurundjeri land, and I pay my respects to traditional custodians, recognising their abiding connection to the land, its waterways and community. It's my privilege to pay respects to their elders and to all the generations who have nurtured this land for over 50,000 years and continue to do so. We believe that acknowledging the past is an essential step in building a better and more equitable future. We recognise the impact of colonisation, its legacy of injustice, and the marginalisation of Aboriginal and Torres Strait Islander peoples. We aim at the Foundation to break down the barriers to justice for all Victorians through our work in research, education and grants. We are committed to making a sincere and positive contribution to a better justice system for all of us, especially those who are vulnerable and most in need. And before I introduce you to our speakers this morning, a couple of housekeeping matters. We are in a webinar format, as you would be aware, so only the panelists will be seen and heard, but there will be time for questions at the end. So please use the Q&A function, and you can also, through that function, as you're no doubt well aware, upvote other people's questions if you're particularly interested in hearing the response to that. And we'll get to as many as we possibly can at the end. We are recording the session, so if you have to depart and you want to hear the rest, then fear not, we will send you the recording, or if you'd like to pass it on to friends and colleagues, then we'd be delighted for distribution far and wide. So as I mentioned, today we're looking at the benefits and the barriers for victim survivors of family violence when it comes to dealing with technology in relation to intervention orders. The move to more online application, assessment and process seems in this day and age inevitable, but it is really critical that we understand the implications of that shift online for everyone in our community. Systems have to work for all of us and not the other way around. So joining us to talk about this morning are Tanya McKenna, Kate Hammond and Hugh McDonald. So let me quickly introduce them. Tanya McKenna is the Partnerships and Community Development Manager at Northern Community Legal Centre. And she's worked in the legal assistance sector for over 25 years, primarily in the community legal and family violence sectors. Her work history has ranged from direct support and advocacy to designing, implementing and evaluating complex community development projects and sector-wide reforms. And we are delighted that Tanya has just joined the Victoria Law Foundation as our newest board member. Dr. Kate Hammond is the Research Manager at the Australian Muslim Women's Centre for Human Rights, and she holds a PhD in Islamic Studies and researches gender, family violence, and barriers to Muslim women's equity in an Australian context. Kate also works in the University of Melbourne's Department of Social Work on family violence research. So as you can see, two people who are eminently qualified to both undertake this research and to share it with us today. Dr. Hugh McDonald is the Acting Research Director here at the Foundation, and he joined us in September 2019 and has worked, as many of you would be aware, across all aspects of our research program, including the Public Understanding of Law Survey, the Data Mapping Project, and the Community Legal Centre's Workforce Survey. Throughout his career, Hugh has worked closely with legal aid commissions, community legal centres, state and federal governments, giving him a very deep understanding of legal institutions and access to justice issues across the country. In a minute, we will hear from Tanya with an overview of the projects, both projects that she and Kate will describe today. And then later, Tanya will return to share the findings of the Justice at Home report, which was supported by the Victorian Legal Services Board and looked at the experience for people participating in remote hearings in specialist family violence courts. She will then introduce Kate Hammond to talk about the research conducted by Northern Community Legal Centre and the Australian Muslim Women's Human Rights Centre, which was funded by us at the VLF, into the benefits and barriers experienced by victim survivors in applying for family violence intervention orders online. And then Hugh will wrap us up with some insights from the PULSE, the Public Understanding of Law survey. So without further ado, let's get the show on the road. Over to you, Tanya.
Thanks, Lynn, and thanks everyone who's come along today to learn about our projects. So as Lynn mentioned, we're going to be referring to two projects, the Barriers to Access project and the Justice at Home project, which I'll describe for you in a moment. These projects were the findings from a body of research that has taken place over the last 12 months or a little bit longer and launched earlier this year. If we could move to the next slide. So I thought I would start with just setting the scene and providing some context as to why these projects were really important to us at Northern Community Legal Centre. So we operate in a catchment that experiences some of Victoria's greatest structural and systemic disadvantage. We service a vastly growing community, so we have two of Melbourne's high growth population corridors within our catchment. And our community is culturally diverse, so about 40% of people speak a language other than English. And a third of Victorians' humanitarian arrivals have settled in our region over the past 5 years. So socioeconomic disadvantage is also significant in our catchment. Rates of family violence are considerably high in comparison to the rest of Victoria. And you can see this is reflected in our data where we have 74% of Northern Community Legal Centre's clients identifying as victim survivors of family violence. We run a duty lawyer service at the Broadmeadows Court for family violence intervention order applicants. And a significant proportion of our work relates to the other legal matters associated with family violence, such as advocacy with child protection, child contact orders, victims of crime assistance, migration support for women on temporary visas, debt and housing issues. So as you can see, legal need in our catchment is significant and demand is growing. And a key focus of our work is to not just respond to legal need through the provision of legal advice, but to also address the systemic barriers that our community experience when they're accessing justice protections. Move on to the next slide. Thanks, Jackie. So people may not be aware if you're outside of Victoria, but we had the Victorian Royal Commission into Family Violence in 2016 that had a raft of recommendations, 227 recommendations, I believe. And the Victorian government committed to implementing all of those recommendations. And our research reports relate to two of those recommendations. So there was a recommendation that the application process that previously was paper-based moved to an online application process. And there was also a recommendation that we move to remote participation of family violence intervention order applicants for their family violence intervention order hearings. There was a time frame for implementing these reforms, but it was really COVID that became the catalyst for moving everything into those online systems. So following these reforms at Northern Community Legal Centre, there were a few things we began to notice. So one, we noticed that the demographics of clients that were accessing our duty lawyer service was changing. And in particular, we noticed that there was less migrant and refugee women that were accessing our service, whereas they are usually a core cohort for us at Northern Community Legal Centre. We also, we then consulted with our partners at the Australian Muslim Women's Centre for Human Rights, and they said that they could definitely see barriers to access being experienced by their clients since we moved to the online forms systems, and also the impact of this upon their service provisions in terms of additional support needed by women to access these forms. So with that, we decided to partner with the Australian Muslim Women's Centre for Human Rights, and funding was received by the Victorian Law Foundation to run a project to unpack the process issues and barriers being faced. Simultaneously, we also had concerns about the move to remote participation, which on the face of it has many benefits for our clients. But we were also having lots of concerns raised around issues with technology, problems with participation, and a range of constraints that were impacting upon that remote participation. And so accordingly, we also applied to the Victorian Legal Services Board and Commissioner for funding to do our Justice at Home project. So this project was an explanation, or is an exploration, of the experience of remote hearings and looking at any impacts upon safety, validation, participation, support needs, and awareness of next steps. So with both these projects, what we wanted to do was document the experience, create a body of evidence, and look at what additional reforms were needed to ensure that everyone in our community could equally access the protections of the justice system. With that intro being done, I will now hand over to Dr. Kate Hammond to talk further about the Barriers to Access project.
Thanks, Tanya. Hi, everyone. As Tanya mentioned, I'll be going through the findings from our Barriers to Access project. I'm Kate Hammond. I'm the Research Manager at the Australian Muslim Women's Centre for Human Rights, or AMWCHA for short. And I'll just give you a quick overview of our service. So next slide, please, Jackie. So AMWCHA is a specialist funded family violence organisation servicing Muslim women in Victoria. We're a national organisation, but our family violence casework services are Victorian based. We've been working in this space for over 30 years, providing family violence and settlement casework, advocacy services, community programs, and also research. And the clients that we support come from a very diverse range of cultural backgrounds and language groups. And in our family violence case management support services in 2023, over 90% of our clients did require in-language services. I'd say it's probably actually closer to 100%. And fortunately, we're able to provide that service through our staff, as all of our family violence case managers are multilingual. Thanks. Next slide, please. So quickly, I just want to acknowledge the broader project team who weren't able to be here today, the rest of the research team, and also our advisory committee, through which we were able to get a lot of support and advice from people from various professional and cultural backgrounds. Just an acknowledgement that AMWCHA, although all of our clients are migrant and refugee women in terms of our family violence case management, we also wanted to be looking to towards other communities who maybe aren't as represented in Muslim communities. Thanks. Next slide. So our research design. Broadly, our research aimed to explore procedural issues and barriers to accessing and navigating the online intervention order application process for migrant and refugee women. And I guess this what we mean by the application process is a few things. So firstly, as we've already mentioned a lot, the actual forms that are involved in the application. So that's the initial application form that's embedded within the MCV website. But then we were also looking at the pre-court information form, which I'm sure a lot of you are familiar with, but just in case anyone isn't, that's the form that victim survivors or AFMs and also respondents are required to fill out prior to their hearing, and that just provides the court with information related to demographics and, importantly, also things like accessibility needs, so whether the AFM requires an interpreter or legal services, or also importantly whether they'd like access to a remote hearing or the early resolution service. So we're looking at those forms, and then we're also looking at other things like the broader, where the forms are embedded on the online system, so within the website, how the website functions, and then also how the information within the forms are actually actioned by the courts, or whether they're actioned, and how the forms are shared with victim survivors as well. So to explore this issue, we conducted interviews with migrant and refugee victim survivors who'd been through the process, and also interviews and focus groups with practitioners. So that included family violence case managers and also lawyers, so practitioners who support women through the process. And in total, we were fortunate enough to interview 10 victim survivors and 30 practitioners who represented 11 services. Next slide, please. So our primary and overarching theme that we found from our research is that many migrant and refugee women are being prevented from accessing the intervention order system without assistance. And this is due to a range of barriers, foremost language barriers. So the actual forms and the application process is primarily or only in English. But not only is it only in English, the English that's used within the forms is quite legalistic English. So even people who felt that they had a strong grasp of English language, say they had professional level of English, felt that didn't necessarily translate to the level of English that's required to fill out a legal document. The online interface itself is difficult to use, and this is related to all of those annoying, buggy, techie issues that you'd imagine when you move to an online system. I guess the issue here is that in the context of experiencing family violence and a very, very high stress situation, the implications of this are a lot more severe. And it's all the more frustrating when you're just trying to go through a process to get protection and you're coming up against these very frustrating tech issues. Another issue that was presented was that the online forms are creating additional safety risks. So this is related to the potential for there to be experiences of technology facilitated abuse, and practitioners did express concerns around monitoring of devices when filling out the forms, and so they were taking extra steps to make sure that the devices that were used to go through the online application were safe for their clients. And then lastly, the existence of the pre-court information form is not well known. And this is due to a range of reasons, but the biggest one being that the dissemination of the pre-court form isn't very standardized across courts. Although there's meant to be a routine procedure for sending out the form, it's not always followed. And so there's a few different ways that this form is disseminated. And that means that sometimes clients aren't receiving the form, or family violence case managers aren't even aware that it's meant to be filled out. And so it's not being filled out. And that can have implications for clients not having access to those really vital supports in the court settings, or access to things like the ERS or remote hearings. Thanks, Jackie. Next slide. So the previous slide we looked at, those are the barriers and those primary issues impacting migrant and refugee women's experiences of the online process. And all of these issues necessitate women seeking support to assist them through that very complex process. Unfortunately, what we also found is that actually obtaining that support is really difficult for some women. So a lot of women reported being essentially passed around from service to service until they could find someone who would be willing to accept them. You know, they'd go to the police say, it's not our responsibility, you should go to the court. They go to the court, and then the court would send them back to their lawyer or their family violence caseworker. And this meant that victim survivors are having to retell their story over and over again. We also found that what ultimately is happening is that the community sector is seen as the last stop in this process, and they are actually the ones that ultimately are holding the responsibility for supporting women through the process. lots of practitioners reported that prior to the introduction of the online application system, it was actually fairly easy to get appointments in the court for assistance with form filling. But now, because people are being redirected back to the community sector, actually obtaining those appointments is really tricky. The appointment times aren't long enough, or interpreters aren't provided, or victim survivors turn up to the appointment at the court for assistance with filling out the form, and they're expected to have the form already filled out, which kind of defeats the purpose. But that is what we were hearing from practitioners. And so ultimately, practitioners are the ones that are providing that support. And this means that time-poor service providers are allocating increased capacity to supporting clients through the online process. And this has flow-on effects to services wait times, but also practitioners' ability to provide supports around other really vital issues, things like very basic needs, food, housing, because a lot of their load is spent on supporting clients through the application process. And this is really exemplified by this quote here from one of the practitioners who said, "I worked in an organisation that was absolutely not supportive of us filling in the intervention order application. It's a legal responsibility. There's a court registrar. This is a court registrar's job. They don't want you to spend 4 hours of your 8-hour shift on one client trying to fill out that form." And lastly, the issue of family violence case managers ultimately providing this support was something that appeared a lot across the family violence practitioners we interviewed. They were concerned that they didn't actually have the required legal expertise to provide the best possible support and to make the best application for their client, because it is a legal document. Thanks. Next one. So all of these issues ultimately led to a lot of legal and social impacts for victim survivors. I guess the primary outcome of all of these issues is that victim survivors' agency in this process is being removed, because their access to the application process is always mediated by a practitioner or someone else. There's always a third party in between them. So it removes a lot of their agency in the process. They're prevented from independently engaging. And of course, there are going to be mental health impacts because of this. That we heard a lot about increased stress, and we also heard stories about people disengaging from the process because it was so complex and frustrating. As I mentioned, the implications of disengaging or not being provided with adequate supports means that there's delays in receiving legal protection. All the time that victim survivors are being passed around from service to service is time that they're not protected. It's time when the intervention order isn't in place. So that is a really obvious safety risk. There's also a risk, I mentioned this before, of not being provided with an interpreter at court, and that's related to not filling in the pre-court information form, and also risk of not being provided access to remote hearings or the early resolution service. So this not being provided with access to the early resolution service means that for some women, that court experience is much more drawn out and much more stressful and traumatic. Thanks. Next slide. So based on these findings, we developed some recommendations, and we view these recommendations as quite targeted and achievable. So firstly, we recommend a complete review of the online intervention order application form and the pre-court form, with particular regard to accessibility, language, user interface, and the discrepancies with the paper form and the online form. I don't know if I mentioned this, but a lot of practitioners said that they actually preferred the paper form or the offline form rather than the online form, which they found a lot more repetitive, and there were things like character limitations. So some practitioners reported actually downloading the paper form from the website and then filling it out on their computer and then emailing it to the court rather than going through the online process, which I think just kind of shows that there might be some issues with how the online form is structured. One way that we recommend that these issues could be addressed is you could combine the initial application and the pre-court form into one document, because a lot of the information that is gathered through the pre-court information form is actually already provided to the court in the initial application. So we suggested that these could be combined, and then you retain the pre-court information form for respondents or for any subsequent hearings. We also recommend that courts arrange interpreters and allow adequate time for assisting victim survivors to complete the forms at court. And this relates to the issue of it being difficult to access those form filling appointments with the registrar. So just making sure that those appointments, they exist in theory, but we need to make sure that they exist in practice as well, and that adequate time is given to victim survivors to accommodate that extra time it takes when you use an interpreter. However, in recognition of the fact that some victim survivors prefer to go through the process alongside someone that they have an established relationship with, so their case manager or their lawyer, we're not necessarily saying that the courts have to take back all of the responsibility for supporting people through the online process. It's just more about this work is being done by the sector, and there needs to be additional resourcing to accommodate that shift from the courts to the sector. And lastly, we recommend investment in reviewing the quality and accessibility of interpreting services so that they're always available in the form filling services at court. And then also, I'm sure you're all familiar with the issue of there being a shortage of interpreters at courts, and also making sure that interpreters have that specialist knowledge related to family violence and the legal knowledge required to fill out application orders and applications form and making the best possible case for clients. And thank you. I'll now pass over to Tanya, who will go through the Justice at Home report.
Thanks so much, Kate, for that excellent summary, which I think really highlights how, as we move to these online platforms, the importance of thinking about who gets excluded in this process and what needs to be done to ensure that everyone's got equal access to justice. I'll now move into talking about the Justice at Home project. So if we could just move to the next slide, Jackie. So in this one, we also did interviews with 15 victim survivors of family violence who had participated in at least one remote IVO hearing in the previous 6 months. And we also did focus groups and semi-structured interviews with about 48 practitioners. So that includes lawyers or family violence workers. And when I say family violence workers, that could be a case manager, it could be a court support person, it could be a crisis response worker. Like all great projects, we greatly benefited by the expertise of our advisory committee, which included the 4 community legal centres that service the courts. The courts that we focused on for this project were Broadmeadows, Sunshine, Heidelberg, or Dandenong. We also had great specialist expertise provided by AMWUCHA, Australian Muslim Women's Centre for Human Rights, and also JIRA, an Aboriginal community-controlled organisation that is a community legal centre responding to family violence. We had the Orange Door, and we also had Court Services Victoria, which was really important for that ongoing engagement and lots of fact-checking about how things are supposed to work along the way. We'll go to the next slide, thanks. So I just want to highlight the diversity of our victim survivors that participated in the research, which broadly reflect the clients that access our community legal sector services as well. So we had a range of ages, reflecting the gendered nature of family violence. 14 out of 15 participants were the primary carer of at least one child. Just under half of the sample were born outside of Australia, and English was a second language for 5 of those people. We had 2 participants identified as Aboriginal or Torres Strait Islander, and 13 of the applications were against a male ex-intimate partner. 1 was against a male adult child, and 1 was against a female parent. And 5 out of 15 participants had experience of attending court remotely and in person, most of them had attended multiple hearings, and that comparison between attending court remotely and in person was really important in terms of being able to pull out some rich data about those different experiences. Excuse me. If we could move to the next slide. Thanks, Jackie. So referring to those experiences of those who had attended court and online, they said that attending online for remote participation was far less stressful and anxiety provoking. It didn't mean that there was no stress or no anxiety. It was still a stressful process, but it really highlighted that level of fear that women have when they're attending court in person, which I know we've seen reported in research, but like listening to women's experiences really drove that home for us. There were participants who had dropped out of the intervention process because they were so scared of the other party, as is reflected in the quote that's there at the moment. So they were fearful for their physical safety, their psychological safety. One participant told us around how even when the other party might say something innocuous, like "you look nice today," they would take that as a very menacing comment based upon their history of behaviours, and the trauma stayed with them for weeks afterwards. So it was a really good reminder of just how difficult that process is. So attending online was far better for a range of reasons. One is that it gave women a real sense of control and autonomy around their access and their time spent while waiting for their hearing. So they talked about how they could still be available to their children. You could stop and make a cup of tea while you were waiting for your hearing. You could go to the bathroom, you could fix your hair, you could go for a walk in the garden, you could do some mindfulness activities. And all of this helped women to keep their anxiety levels manageable while they were waiting for their hearing. And this in turn assists them to actually be participating in their hearing by the time their hearing actually gets called. Next slide, thanks. So another really important finding was that it minimised the impact of systems abuse. So this is where the other party is dragging out proceedings, there's lots of adjournments and there's lots of matters being listed at court. So clients talked about how inconvenient and stressful and taxing that was when you have to keep attending court for hearings. However, that impact was minimised. Obviously, the online engagement is far less time consuming and not as stressful. Accessibility was a really important factor as well. As noted, most of our participants had caring responsibilities for children. We also had those with a disability, and for these women in particular, it reduced the costs involved. And we have to remember that most women experiencing family violence have often experienced financial abuse. They may have limited access to money. The costs of going to court, of getting childcare, is significant and a real barrier for them. So the accessibility of remote participation was definitely a highlight for them. And they also highlighted how important it was to have a trusted legal representative and a support person in place. And many of our participants did have a support worker that was in contact with them during the hearing. One or two, I think, had their hearings take place from a case manager's office where they were supported before, during and after the hearing. One of the limitations of this study is that all of our referrals for participation for victim survivors came from other community legal centres, which meant that everyone we interviewed had a lawyer representing them at the hearing. What we weren't able to uncover is what is this experience like when you don't have a lawyer? And we'll be noting some of the participation issues, which means that having legal representation is even more important when we move to remote participation. Next slide, thank you. So moving on to the challenges that came out through our findings. So firstly, it was really apparent that this wasn't being made easily available to people. Nearly everyone in our study had found out about the option of remote participation through their lawyer. So more needs to be done around ensuring that everyone is made aware of this option. As Kate mentioned earlier, it is a two-step process on the application front. So you have to do the application, but then there is another form, the PCI form, pre-court information form, which is where you get to nominate if you'd like to attend in person or online. And from what we could see, the majority of people weren't aware of this form. They were only filling out the form once their lawyer had told them to. Another significant concern was that they would be perceived as less credible witnesses. So women said that they were, the quote here says, I was humming and hawing so much because I was weighing up the judge taking me seriously and me being uncomfortable and feeling unsafe and just waiting till everyone goes so I can get in my car and go home. Magistrates need to understand that it's not that I can't be bothered coming in. Like there's more reasons behind why I'm not coming in. And just because that person there in their work clothes and break doesn't mean I haven't not been sleeping for the past week, and I can't wait for this to be over and done with. So women really were concerned that one, they wouldn't be taken as seriously by the magistrate, that they would be seen as not making an effort to come to court. And they were also concerned that the cues that a magistrates get from seeing someone's level of fear on their face and their body language would not be apparent by attending remotely. And this was also a concern that was echoed by practitioners, which we will touch on shortly. Next slide, thanks, Jackie. So just because people had online hearings did not mean it was a more efficient process. So we know when women are attending court that they are often waiting around all day, but the same was due for the online process, which doesn't seem necessary in this day of modern technology. So it was up to 6 hours that women were waiting for their hearings to be called. So they might be told to log in at 10 a.m, but it may not be until later in the afternoon. And during that time, they're exposed to all of the other hearings which are taking place. So it's kind of the opposite of a trauma-informed response. We're exposing women to lots of hearings, lots of stories, and that was increasing their anxiety and their distress while waiting for their own hearing to take place. And you can see in this quote, she says, I had to listen to all the lives of those 20 people, their names, what happened, all the details. That's a breach of privacy, you know. And she also mentions how it made her feel really depressed. Another unexpected finding was distress at having their image projected on this screen in view of the perpetrator. So they are attending remotely from home, but the screen is quite large in the court for everyone to see. They did not want to be seen by the other party, and lawyers also said that clients constantly asked about not being able to be visible. They didn't want the other party, the perpetrator of violence, to see how they looked, to see if they had changed their hair. They didn't want them picking up on visual cues around where they might be living. And really importantly, they didn't want the other party to see that they were still really distressed and scared. So they wanted a kind of complete disconnect from any kind of engagement visually with the other party. Again, we'll talk to some recommendations that we have around how this could easily perhaps be changed. Next slide, thanks, Jackie. So difficulties in participating and having a voice, and I think this quote from Nell is really important. You're just there, it's like you're nothing, it's all about you, and there's no regard for you as a person. It was like I wasn't there, I was a number. No one looked at me, I was totally ignored. So you can see in this matter, Nell felt completely invisible from her experience of attending remotely. And of all of our participants, Nell was the only one that said that in future, she wouldn't attend remotely, she would go to court in person because she did not feel like she was given any opportunity to be part of the proceedings whatsoever. And this is really important, particularly where you might have, for instance, a police application. And if the AFM, affected family member, is not aligned with what the police are seeking in terms of conditions on their order, that needs to be made apparent to the magistrate hearing the matter as well. So Participation is really important to getting effective legal outcomes with the right conditions for the victim survivor, for the children as well. And if we don't have that participation, we have less adequate legal outcomes, which often then leads to needing to vary orders and going back to court again. Nell's experience was also compounded by restricted opportunity to commute with the lawyer. So this was raised by our participants that if misinformation is provided to the court or something happens, which means the lawyer then needs to communicate with their client for updated instructions, there isn't the opportunity to have that communication. And they reflected that if you were in court, you could tap your lawyer on the shoulder to let them know, or you could whisper or do some very quiet communication to be involved in the hearing and make sure what's being presented was accurate information that aligned with what they wanted. Next slide, thanks, Jackie. Now, no surprise, technology issues was a big one that came up in the issues, and it's something that we were well aware of as a service beforehand, in that we often have clients who drop out of the remote hearing because something's gone wrong with the link, or they've got some technology issues of some kind. Recognising that for many victim survivors, they may be in a refuge, they might just be using their phone rather than having a laptop. The Wi-Fi may not be entirely adequate. And the difficulty was if the link doesn't work, they have no way of directly notifying the court. They would have to ring the court, be on hold for the register, try and get through. By the time they actually notify the court, their hearing will be over. So this was a real concern, and practitioners also referred to hearings just going ahead, regardless of if the victim survivor had dropped out or not, and not being able to have matters stood down to contact the client. A big factor that was raised was around, and one thing that we saw through the data was that there was very inconsistent information and dissemination of information to victim survivors prior to their hearing. So, for example, some people would get instructions and a link for joining a few days before the hearing. Some didn't until the day of the hearing. So you can imagine that causes a considerable amount of stress on what is already a stressful day. You've been building up to this hearing. It's really important. It's really scary. But on the day, you still haven't received the link. So you're contacting your worker, you're contacting the court, you're trying to find out what's going on. And that time should be spent preparing, relaxing, getting ready for the event. And so there really needs to be much greater consistency around how and when information is provided from the court, and also information about what would happen on the day. For instance, the people spoke about the shock of not realising that they would be projected on a large screen. What we know is that the more information you can give people beforehand about what to expect, the not less anxious, but it will minimise anxiety to some extent. Next slide, thank you. So we're now going to move on to, as mentioned earlier, we did focus groups and semi-structured interviews with practitioners who were lawyers and family violence workers. And we'll now look at the findings from those from a practitioner perspective, having now looked from a client perspective. So one thing that was really apparent was that practitioners, family violence workers and lawyers go to a lot of effort to make sure their clients are safe when attending court. There is a lot of safety planning is done. They might be trying to meet them in a safe location to escort them into the court. And so remote participation took away one of those really important responsibilities, and practitioners experienced less stress and concern for their clients. Interestingly, they also had reduced concern for their own safety, and this is something we hadn't really thought about. But if you're a family violence support worker, it's really obvious if you don't need to go to court yourself to support your client. They are also then not being exposed to the other party. And this is a source of concern where they have something that is showing their name and they're quite visible to the other party, and they're worried that retaliation may take place. They also mentioned their ability to maximise their time and support for clients as a more efficient process compared to having to go to court and wait all day with their client for a matter to be called. They were able to see more clients during the time, or support more clients during the time that they had available to them. So next slide, thank you. So moving on to the challenge. So again, aligning with what we've already found, practitioners spoke about not being offered the opportunity to have remote participation, but in this context, it was actually around some courts refusing to have it, or particular magistrates preferring to have people there in person. So you can see in the quote, one person referred to a magistrate who expected and demanded that everyone be there in person. So it's those kinds of really polar opposite inconsistencies that create challenges. And from a practitioner perspective, it means you can't tell your client, you can't offer all of the benefits of remote participation for their clients. And, you know, with the recommendation and the changes to the Family Violence Protection Act do say that this is an option that must be available. So there's definitely some work that needs to be done about consistency. They also reflected about concerns that clients will have poorer legal outcomes. And so there was concerns that a preference by some for in-person hearings meant that potentially those appearing remotely also were treated a little bit differently. And a lack of understanding perhaps around the level of fear being experienced, and that is why clients choose to attend remotely rather than coming in person for their hearings. So we'll talk to that later when we get to our recommendations. Next slide, thank you. So the inconsistency around some magistrates did allow cameras to be turned off, and so this would support those clients who don't want to be visible to the other party, but some refuse to allow joining by telephone audio. The benefits for telephone audio is that for those who have poor internet connections and video conferencing doesn't work, it's an alternative form of accessing their hearing. But if that's not being allowed by magistrates, then again, that is problematic for those who have those concerns or technology issues as well. And aligning with what we found with the huge wait time for many people, inconsistent scheduling times. So having open links where they're being exposed to all of those other hearings, as opposed to a link with a specific time, is inconsistently done across courts. Next slide, thanks. So it was noted that there is reduced proximity to specialist support, and I do want to highlight that there is a remote hearing specialist support service being offered by the Magistrates Court of Victoria. But from our findings, we found that this service wasn't widely known, or people weren't clear on how to access this service. And practitioners talked about how it is easier for them once they've got a client there in person, following that hearing, to be able to hand them over to the family violence applicant support worker at court, or to a practitioner from one of the family violence services at court for further follow-up, immediate safety planning, anything that they might need following the hearing. So court can be quite a good connector in that sense for getting people together in the same space. A really big concern was around communication issues with interpreters. So in the remote participation environment, the interpreter is at the court. The AFM, affected family member, victim survivor, is obviously attending from home. But it means that background noise is impacting upon their ability to understand the interpreter. If you have a magistrate who is not pausing completely for an interpreter to interpret, they've got the interpreter noise, background noise, the magistrate speaking. Audio is really difficult to hear, particularly those on their phones and with poor audio. And you can see from the quote here was a practitioner who had 2 different interpreters for the client and for the other party, speaking 2 different languages simultaneously. So obviously in this context, it does not work at all. We think that some of these could be resolved potentially by ensuring that you have an interpreter with the person from a remote location, such as a family violence service, so they actually have an interpreter sitting next to them. So practitioners also spoke about the issues of not being able to communicate with their clients during hearings. So in court, you can turn around and quickly check something with your client if they're sitting right behind you. You're not able to do that in a remote hearing. And they also reflected that magistrates generally weren't allowing them to stand matters down to consult with their client throughout a hearing as well. So aligning with our findings of victim survivors, communication between legal representatives and clients is problematic during remote hearings, and particularly sometimes practitioners and lawyers spoke about where the hearing was proceeding and the client wasn't there on their web link, often because technology may have dropped out and proceedings just going ahead generally, and then them not having the chance to contact the client to say, what's happened, why aren't you on the link? So that was raised as a kind of significant concern, particularly when the client had said that they definitely want to be involved and at the hearing. Next slide, thank you. We're on to our key recommendations. So these are some of the recommendations we've made in response to the findings. So firstly, we need to standardise and make transparent the processes and practices regarding access to remote hearings, and we want guidelines and, where possible, and appropriate practice directions. So we want to ensure that all victim survivors have access to remote participation. But also, if the guidelines and directions are transparent on a website, it means that we can hold registrars or other court staff accountable if things aren't happening as should be. So in an ideal world, we want to have information about how will you receive information about your hearing, when will you receive it, when will you receive the link. We want all these things to be quite visible. The findings highlighted that a practical model of support is really important, and that this has often been taken on by services who aren't necessarily funded to do this, such as AMWUCHA and other partner agencies. But we definitely noted how important it was to our clients to have that support available before, during, and after a hearing. And also, I think the findings point to the fact that remote participation would be really difficult without a lawyer there representing you in court. So reflecting on our findings around problems with technology, problems with audio, etc., legal representation is heightened, and we need to ensure there's adequate funding for every person participating at a hearing to have access to a duty lawyer service. Our lawyers are fantastic. They do a wonderful job when they're at court, but there is a limit to how many people they can assist on one particular day. They're often trying to do 5 things at once with 5 different people. So additional resourcing is important. Providing approximate scheduling times for hearings. We want to get away from people having 5 or 6 hours of exposure to other hearings while waiting. And we also think a virtual waiting room would be a really good way of ensuring that that exposure is minimised as well. Providing victim survivors with the option of turning the camera off or being able to join by telephone audio would be significantly important and would achieve a number of purposes, including not being visible and addressing technology issues where web links have failed. Or alternatively, the court could position the monitor screen so they're out of sight of the perpetrator but still visible to the magistrate. We think that judicial training incorporating the lived experience of victim survivors attending court is really important, because we really want to drive home understanding around how difficult that experience is for women attending court, and why this reform is actually really important for victim survivors of family violence. And so getting away from those who may think or may request that people attend in person instead of attending online. Next slide, thanks. There were some really great protocols that were developed for magistrates during the COVID period, and they included a set of protocols around how magistrates introduce themselves at the start of the hearing, the importance of signposting up front when breaks will be taken, and opportunities for the person to participate and clarify any information provided, and checking and understanding and inviting clarification before finalising those matters. So we think those guidelines were great. They probably need a refresh because they sound very COVID-y when you read them. But those type of guidelines for magistrates would certainly alleviate those issues of feeling invisible through remote participation. We would also like to see a direct telephone number to a tech person at court. It's an important part of our wish list, so that when tech fails, the AFM can contact someone directly to notify the magistrate, notify the court, and hopefully have matters stood down so that they can participate by telephone or in some other way. Having information packs, I know that there are sometimes emails sent to AFMs that have information, but not always, and in most of our clients participating didn't receive pre-court information. And so to have a set pack of information, what to expect at your hearing, how to join, when to join, etc., would be wonderful, and with plenty of time before the hearing so they've got that information. Allowing matters to be stood down so we can improve communication between lawyers and clients when there needs to be during a hearing, and allowing sufficient time for interpreting. So looking at potentially other models of having the client participate, so that could be through the Orange Door or a support worker's office where the interpreter can be with them side by side, so that we're ensuring that migrant and refugee women aren't being further marginalised in this process of seeking an intervention order. Next slide, thank you. So just some key tech takeaways. So tech systems and reform can have wonderful benefits and can enhance access to justice, but not always equally for everyone. And I think the Barriers to Access project that Kate spoke to really highlighted the concerns for migrant and refugee women who are not English speaking and the inaccessibility of that system. So we want to see that any reforms include a risk assessment around who might be negatively impacted, and we need to fully resource alternative access points so that online systems are not the only access point. We don't want to have a situation where migrant and refugee women are dropping out of the system because we've made it just too hard and there aren't the supports available that are needed for them to navigate those online systems. In relation to remote participation, I think what our findings demonstrate is that this is an absolute game changer for victim survivors of family violence when it's done right. We're not there yet in Victoria, but there are so many small changes we could make, which I think would have immediate impact. So if we can have the right supports in place, we can have the systems operating smoothly, when magistrates are making allowances and accommodating remote participation, then this is a wonderful reform. We also want to see better consultation with key stakeholders around reforms in courts, including the legal services that service those courts. And this was something that was highlighted in a recent NLAP review around consultation with court users for systemic reforms. We totally endorse that. It really highlights that it's one thing to make the changes and implement the reforms, but we must monitor their effectiveness. And when we do that, we have to include the voices of the people that the systems are designed to protect. We had some wonderful insights from our research that came from those interviews. So stakeholder feedback alone is not enough. We need to really explore that user experience. And also recognise that if we don't get it right in the first instance, it doesn't necessarily lead to more efficient systems. So, we had an example earlier where we talked about lack of participation may result in inadequate legal outcomes. It may result in orders that need to be varied or to go back to court. So when we have repeated court matters for things that could have been resolved in the first instance, we are not moving to a more efficient system. And finally, safety must always be a priority over efficiency. So it just makes my heart sink when we, heard those stories from practitioners about migrant and refugee women going from service to court to police, trying to get support with filling in the forms, dropping out of the system where it became too hard for them, and that's just not good enough. So any systemic issues that lead to delays in accessing legal protections or inappropriate legal outcomes must be addressed as a priority. There are our key takeaways. I guess I'll just finish off with a little update. It's one thing to write the reports. Advocating for change is a whole big second stage of the project, which is the phase that we're in at the moment. We were asked by courts to consult on a revised version of the pre-court information form. We weren't given a lot of time to do this. We had 24 hours, but having this body of work available to us to pull from the recommendations and the evidence that's within there and submit to the court just showed us how valuable it is to have this body of work that's been done. And we were also yesterday invited to speak with the family violence team from the Magistrates Court of Victoria to talk about some of the changes. And so it highlighted that there is a lot of rapid change happening in this space, including a new PCIF form that will be coming out. So from our perspective, it's really exciting to see that research and advocacy in action, and to see responsivity from the sector for the work that's been done. So I'd just like to finish by thanking our funding bodies, the Victorian Law Foundation and the Victorian Legal Services Board and Commissioner, for recognising the value of this work and supporting us to undertake it. I will now hand over to Dr. Hugh McDonald from the Victorian Law Foundation.
Thanks very much, Kate and Tanya. Lots of important findings that you've shared with us this morning. I've got a few immediate reflections, and particularly the lessons the research has for all of us who are really interested in those classic access to justice issues, and who are concerned that the justice system must be accessible by those that's intended to serve. I mean, I think that the findings are a timely reminder that justice systems reforms, be they technology-based or other forms of changes, can affect different groups and different groups of users differently, and that some reforms can have aspects that are beneficial as well as being detrimental. I think justice reform is hard and important work, but the findings here, I think, demonstrate why it's so important to be mindful of, to design for, to actively monitor the impacts and consequences for different users. Yesterday, I came across a quote from the chief of content at Netflix, where she recently said, if you try to make a TV show for everyone, you make a show for no one. And that's similar to the principle in design, that if you design for everyone, you're designing for no one. So in a nutshell, it's nearly impossible to create something that will work well for everyone. People have different wants, needs, preferences, and what works for one person or group may not work well or even at all for another. We've got a similar mantra in access to justice research. So access to justice research is frequently cautioning that one size fits all services or processes don't fit everyone equally. This is sort of based on extensive research demonstrating how access to justice and legal needs, it varies across the community. And again, we know from research that people have different wants, needs, preferences, and capabilities, and that they often behave in ways that are markedly different than how institutions and processes would like them to behave. So when it comes to technology, the access to justice research community has widely been cautioning that technology-based justice reforms are likely to work better for some people than others, and that while reforms can increase ease of access for some, they can heighten access barriers for others. So researchers caution against sort of blunt strategies and approaches such as digital only or digital first reforms, and are frequently identifying, and I think we heard that really clearly today, the need for additional or augmented forms of services and processes that some people are likely to need to be able to negotiate what can be really fierce access to justice barriers. Findings from our public understanding of law survey clearly demonstrate inequality in access to justice and legal needs. And just a couple of findings that I think are useful and relevant in this morning's context is we found that nearly 20% of the Victorian community had what we described as marginal or inadequate practical legal literacy skills. So that's things like difficulties handling and filling out forms. We also found that just over 25% of the community were likely to need major support to interact with law and legal issues online. So that's a sizable segment of the community that we really need to be thinking about during following reforms. And that's really the reform, design and access to justice challenge for things like online forms, for things like remote hearings, as the findings this morning demonstrate. When it comes to justice system reforms, I think there are also several additional design challenges. So for one, we frequently see there's the well-known principle of having equality under the law. Basically, requiring that the law should apply equally to all people, regardless of their status in society. But to have equality under the law, people need to be able to access and participate in their legal system. I could go on, but I think I'd really like to thank Kate and Tanya again for the really fantastic research they've been doing and that they've shared today, and move on to what I can see are some questions coming through. So over to you, Lynn.
Thank you, Hugh. Thank you so much. And can I invite Tanya and Kate to pop their cameras on and join us to respond to some of the questions that have come through. Outstanding presentations. That was really insightful work in terms of the dimensions of both challenge and opportunity, I think, that that present themselves through these changes in family violence process. I'll start with an observation which I think echoes probably everyone on the call this morning, that revelation around people sitting for extended periods of time and hearing the stories of other applicants in the process before they get to their own hearing is very confronting. And that was a comment that came through. But let's turn to some of the questions. And Sam has put one that I think extends, Tanya, on remarks you've already made about some of the response so far to the research. Where are the recommendations from the barriers to access going for consideration? So that goes to your work, Kate, but I think for both of you, it's about, okay, these findings are really useful. So where do you put them, and what prospect do you think there is for change? Kate, do you want to start that?
Thank you. Thanks for that question. Yeah, so as Tanya said, we're now in the more advocacy stage of the research. So we have been having meetings here and there with various people. As Tanya mentioned, we have been speaking with MCV and Court Services Victoria about what the scope is to actually look at those recommendations and hopefully implement some. But we also wanted to hear about what is already in the process, because of the nature of digital, the digital space, things move very quickly. So just as an example, at the start of our research, we were hearing from a lot of practitioners about how there were some troubles with the form relating to not being able to save the form. So you had to fill it out in one go, and sometimes it takes up to 4 hours, and then people have to leave halfway, or if they don't know some of the answers, so you can't progress the form. You really need to be able to save your progress and come back to it. But then over the course of the research, they actually fixed that issue. So things are actually progressing, and it's really good to have those meetings and to be able to come here and talk today about things that have actually happened since the research has come out, and even during the research. And so we are in conversations. As Tanya mentioned, there's a review of the PCIF, and hopefully NCLC's recommendations to those changes are taken into account. And interestingly, we also heard some feedback on one of our recommendations relating to combining the initial application with the pre-court information form. And we were told that that is not possible due to some back-end digital stuff related to how the information is disseminated to the various courts. So I think we'll have to follow up on that one, but we are continuing talks about this. Tanya, did you want to add anything?
No, I think you've covered it pretty well, Kate. I guess the only other thing is just to, at a local level, so obviously being able to talk to these findings at our various court user groups has been really great. And seeing some changes at a local level that are responsive to the recommendations as well. And I believe our partner organisations that also participate in this research is using it in the same way as well.
Tanya, I might hold you for a sec, because Ruth has put a question that came to me as well about whether or not victim survivors could be sent a text when their matter was coming up. I mean, I get one from, tradespeople who come, or my hairdresser, or, all sorts of people in our world are very easily accommodating that kind of responsive communication. Is that something that you pushed with the court, or that that you're aware it might be coming?
Look, we haven't kind of focused on the detail about how it should happen, but just that generally people should get an approximate time. Whether that works better from a text, or what is the best way of doing that, I guess I haven't got the back end knowledge of the functioning of the courts to be able to answer how well that would work, but there is surely a better way than people waiting for 6 hours. And so, if it's a window of 20 minutes that their hearing might be called, great, totally understand that. But yeah, we can certainly do better in that space.
I mean, we all understand that at times court lists can blow out, but that sort of level of communication and awareness across all the participants, I think, has got to be more straightforward with the tech that we have available to us, and absolutely critical. A great comment from Ken Hui, who has praised the presentation, saying this has been very insightful, and that they work on a transformation and innovation in the Singapore courts, which is a fascinating extension of our jurisdiction today. So great to have you with us, Ken Hui. And their view that we need a mix of high tech and high touch, which is a phrase that we hear from time to time in this world, where high tech tools can help those on one side of the digital divide, but for those on the other side who need that human connection and hand-holding, high touch has got to be unavoidable. And I think this goes to your comments as well, Hugh, together with what we heard through the recommendations from Kate and Tanya, that we can't anticipate that one response is going to be sufficient. But that comes with consequences around the demands on courts and court services and court personnel to be able to respond in diverse ways to people coming for process. Not to say that that's not absolutely essential, but you can see the challenge there in terms of both the tech demand and the time cost in being able to respond in different ways. Have you got anything further to add there, Hugh?
Yeah, I think that's the exact challenge. And I think the really interesting aspect of that is what we need to do to know if we can get to a win-win situation where processes and practices, be it highly digital for some and high touch for others, that can get to a sweet spot where it's beneficial for everyone, including the efficiency and effectiveness of the courts themselves, where we know that's where a lot of costs are incurred. So if that process can be working as well as it can, what the old ideas around higher levels of maybe high touch upstream that has downstream benefits, both for people involved in those processes as well as the institutions themselves. And I think that's beholden on a lot of us to be striving to determine and work out if that's possible and where that sits.
Yes, indeed. Lots more work to be done there, Kate and Tanya, another research project or 7. Kate, there's a comment around the plain language in forms and whether or not that was, a really key barrier for people. I think most of us have encountered forms that are hard to read and comprehend, even those of us who have English as a first language and probably significant levels of literacy, and they can be really tough. Do you think better plain language would go a long way?
Yeah, and this was borne out in our findings. So it wasn't just that they were in English, it's that the English that was used was very complicated and legal language. And so going through that form, even when you have a high level of English language skills, is still tricky. And as part of our recommendations around reviewing the forms, like related to accessibility and function, but also language in terms of making it simpler, more straightforward, making the structure more narrative. But then we also there were also ideas thrown around, say, if there was a necessary legal word to be included, including like, I'm forgetting what they're called. There's a question mark with a circle and you hover your mouse over it and it gives you things like that. Or more information at the top of the form that describes the content and what's required.
Yeah, I think that would go an awfully long way. Tanya, a really interesting question about whether or not court appearances were at times disrupted or delayed because of a lack of AV facilities for accused people in prisons, and were victim survivors required to attend court in person because of those sorts of tech challenges. Is that something that you came across?
So in our in our data, when there was tech challenges, so most commonly the web link dropping out or the Wi-Fi not working and our clients not being able to get back into it. So one of the main concerns was that hearings would just proceed regardless. So even if lawyers asked for matters to be stood down so they could contact the client, the magistrates would be, well, you're here representing the client, so we can just proceed. So in that context, it became a concern just around participation. And I think I mentioned that there wasn't an easy way for the client to get in contact with the court to let them know or to make any kind of alternative arrangements. So generally things went ahead, no delays whatsoever.
So the other question around remote hearings, which I think is also really on point, Ruth, with her question around whether or not children at home were exposed to hearings conducted remotely and the potential consequences for them, which could be quite devastating. Tanya, did you have any insights on that?
Yeah, this was something I also wondered about going into this research. So it was something we asked about and explored. It was not raised as an issue with any of our research participants. We did ask around how children were supported during this time or looked after during this time. So sometimes it might be that there's another family member that's come to the house, or it might be that we're using video games with headphones in a way to ensure that kids weren't actually listening to the proceedings and what was going on. So our participants all seemed to manage it and did not flag it as an issue or concern from their perspective.
Good. Okay. So I think to return to the theme that we've touched on a couple of times, the tension, I suppose, around funding and sort of implementation of some reforms. Some are clearly going to be more difficult than others to implement. And as Pavel has pointed out, a lot of this goes to courts and beyond, to police and to other agencies that might be participating in the process. And they point out that without substantial funding across the board, this true revelation and revolution around accessibility might be difficult to pull off. So what are the things that we can do within a fairly constrained budget environment to improve client-centeredness? Kate, what would your top 3 picks be?
Oh, you really put me on the spot there. This is the thing with this whole sector is everyone is really constrained. Everyone is overworked, and you know, everyone, I think, thinks that they're the most overworked. And you know, it's all relative. Like there's so much that needs to be done. And I think what we found, I guess I'm just speaking specifically to our findings, is that really the last stop is the community sector, because they know they have a responsibility to their client, and they know if they don't help them, their client will disengage, their client won't be helped. I guess other than additional resourcing, I guess other than additional resourcing, which of course it's always necessary to increase funding to the sector, we do just are advocating for more of a shared responsibility in this space. It shouldn't solely be left to the sector. So a bit more collaboration, a bit more taking accountability of people's roles in this space rather than passing clients around. And where different services can help, they should help.
Yes, that seems a really useful and appropriate recipe. Tanya, do you want to add that?
Yeah, I guess I just wanted to make the comment that so many of the recommendations that came out of Justice at Home don't cost anything, well, or very minimal cost to actually implement. So we can improve participation just through some protocols around how we conduct hearings. To me, it doesn't look like it should cost a lot to have a scheduled hearing time. Even some of the tech reforms, setting up virtual waiting rooms as an example, it's like we have the technology readily available. It's not like we have to reinvent a whole new software system to be able to make those kind of changes. You know, providing people with the option of joining by telephone audio if needed. So there's just so many things which government should love because it's not costly and it can be implemented really quickly and easily. Some of the things we've asked for are a little bit more costly, but generally I just think there's a massive amount of improvement we can have with very little cost. It's just some changes of practice.
Yes, no, that's a very sound point. And Hugh, I'll just finish this point with you, because it seems to me from both Tanya and Kate's remarks that there is an issue around support. And as Kate's pointed out, this often ends with the community sector, and you know, we all know the pressure that brings to bear. But is there a question here around sort of or re-regulation in order to help more people with appropriately trained people who may not be lawyers, but who have extensive experience in being able to address some of these form issues or some of the pre-court support? And I know that there are family violence supports in place, but it seems to me that there are some points where that defaults to lawyers, and maybe we can do better than that.
Yeah, absolutely. So there's various views that in certain areas of law, you may not necessarily need a lawyer to be providing the types of supports that a lot of people need. Sometimes you might. There are options for having, it's a horrible phrase, non-legal person, but a lay person who has really good understanding and experience, and otherwise could be trained to perform, to both support people, to increase their ability to handle and manage their circumstances. And that also provides an opportunity to hook in and partner with various other services as well. So that's a really interesting service model. We have various examples of integrated forms of practice between the legal world and the lay world. Again, a horrible expression. But I think, I think one of the other things I was struck by when Tanya was talking, and when Kate was mentioning the sheer rapid nature of change sometimes, which makes having, I'm going to say this, I'm a researcher, but it makes the research even more important to have it available, to have people who have done it, understand it, and can bring it to bear in that moment. And sometimes it's a quick and a unique aligning of the stars where sometimes having research evidence can make a huge difference to policy and decision making, and once again underlines just how important this type of work is.
Perfect moment, I think, to draw us to a close, because I think we are beginning to see some movement, as Tanya and Kate have described, and clearly there is, very sound evidence from both your pieces of outstanding research to drive that even further. So congratulations on the work, and we will watch progress in this area with significant interest, and it's been a delight to have you both with us. So if I can thank formally Tanya McKenna, Kate Hammond, and Hugh McDonald for being with us this morning for this really, really interesting session. It's been, I think, a terrific exploration of some of the benefits and the challenges in the world in which we are now moving. Thank you also to all of our attendees for coming, and just a reminder that the video will be sent to you, so fear not if you've missed the beginning or the end and you need to catch up. The Research Network events, of which this is one, are held quarterly, and our aim at the Foundation is always to bring you insights both from the domestic environment but also internationally on access to justice and legal needs. So if you've got any ideas for sessions that you'd like to see us set up, or you've got work underway that you think would be tremendous to share, then we would love to hear from you. So please get in touch. And we will look forward very much to that conversation. And my great thanks, as always, to Neil Hagland and Jackie Matthews for making the session happen today. Without them, we would not be in the polished environment in which we sit. And we look forward very much to seeing you again next time, and have a great day. Cheers.